Okay, great. Well, we might kick off. Well, welcome everybody to our webinar on privacy and data protection. My name is Alex Solo. I'm the co-founder of Sprintlaw, and I'll be running the session today. For those of you who don't know who Sprintlaw are, just a quick summary: we're an online law firm for small businesses. We're very different to your traditional sorts of lawyers. We're sort of a tech-enabled legal firm. We operate completely online. We have lawyers that kind of work from all around Australia, and we're also in the UK and New Zealand as well. And one of the advantages of using us is that we have data-backed documents. So we have lots and lots of small business clients. We're looking at patterns and trends in the different sorts of documents that small businesses need, and we feed that into the legal advice that we give. So sort of very high quality and very affordable is the core elements of our model. We're recently named Asia Pacific's fastest growing legal business, which I'm very proud of. We have a bit over 4,000 clients, lots of positive reviews, and a team of 50 staff. And here are a bunch of awards that I'm very proud of. Before I get into the details of today's session, just to let you know, this month we're focusing on privacy in light of some of the recent changes to privacy laws. We just want to make sure that all of our clients and anyone attending this webinar that's sort of running or involved in a small business is kind of aware of their privacy obligations. So if you don't have these documents, privacy policy, email disclaimer, website terms of use, cookie policy, we recommend these for pretty much all businesses to have. We have a bundle that we're doing at quite a discounted rate for Feb. If you have some of this stuff, but there's other privacy related legal documents that you might need, and I'll cover some of what those are in this session. We're doing a general discount of 10% on any privacy related services. If you're a Sprintlaw member, you get an extra 10% off all the prices I mentioned. So this would be $450 or 20% off. So if you're interested, we'll have some info about how to access that, I think, in the chat. So getting into the content for today, this is kind of what I'm going to run through. First, just want to start off by covering what happened in the Optus and Medibank data breaches, which many of you would have heard about in the news. Sort of in the last quarter of last year. Run through why you should care as a smaller business about these data breaches. And then I'll be going through some of the law stuff. So what are your privacy obligations? And there's a few different areas we'll cover. Firstly, just ongoing compliance, your day-to-day privacy compliance under the Privacy Act and other acts. We'll then talk specifically about data breaches, what to do if there is a data breach in your organization, or sort of how to plan for one. Hopefully it won't occur, of course, but what to do if there is one. And then we'll cover a few other prudent semi-legal or non-legal steps that you might want to take to sort of think a bit about privacy and data protection and how you can be across the risk management aspects in your business. Finally, I'll cover the new privacy laws, or rather changes to the privacy laws that happened in December 2022. And the information that you need to be aware of, flowing from those new privacy laws. If you have questions, we've got a Q&A feature, a chat feature. Feel free to drop them along the way. I'll try and answer as I go if it makes sense, but I'll also try and leave a little bit of time at the end to cover any questions that I don't get to cover. So definitely feel free to use that function and engage a little bit with the content. So just to kick things off, we'll chat a little bit about the Optus data breach. For those that don't know exactly what happened in September 2022, Optus was the victim of a cyber attack that resulted in the disclosure of a lot of their customers' personal information. And this is things like name, date of birth, email addresses, driver's license, Medicare card, passport numbers. All this stuff may have been, and in many cases was exposed. It's not clear how this data breach actually happened, how the cyber attack occurred, but it's rumored to be the result of some form of human error. About a month later, Medibank had a sort of similar incident, October 22. They released a statement, advising that they'd been contacted by criminals that claimed to have stolen Medibank private and AHM data and were requesting a sort of ransom payment, which Medibank refused to pay. And a few weeks later, it was confirmed that the criminal did in fact have the data, and it was leaked onto the dark web. Information about people's names, addresses, date of birth, Medicare numbers, policy numbers, and more was sort of exposed. And again, not 100% clear how it occurred, but again, looks to be a human error related incident. They stole a username and password from someone with high level access to Medibank's system and used that to kind of get in and initiate the attack. So obviously, Optus and Medibank are very large companies, and a question for smaller organizations is sort of why should you care about data protection? I can think of at least 4 reasons, which we have on this slide. I mean, the first is threats are just increasing. For big and small organizations alike. Cybersecurity incidents are costing the Australian economy an estimated 29 billion annually. The second is that customers care a lot more. When these high-profile data breaches happen, people become more conscious and aware of the protection of their personal information. And if you're dealing with consumers or even other businesses in your organization, increasingly you're going to start to get questions around, what's happening with my personal information when I give it to you? How protected is it going to be? And they're going to be asking for transparency from their suppliers. And certainly at Sprintlaw, on the back of those data breach incidents, we had a significant uplift in the percentage of our customers that were asking more detailed questions about our data protection practices, our privacy policies, and our cybersecurity, when they're providing us information. So, there's really, a customer experience or kind of commercial reason to be thinking about this as well, just so you can, provide customers with that peace of mind. The third is that regulators are increasing enforcement action. The OAIC is the main privacy regulator in Australia, but also, the ACCC, ASIC, APRA in the financial industry, and FIRB, the Foreign Investment Review Board. All of these regulators have some form of privacy enforcement powers, and they're increasing the frequency of enforcement action. The OAIC was, for many years, referred to sort of by privacy lawyers as a bit of a toothless tiger, in that it had a whole bunch of enforcement powers, but it never really actually enforced things against many organizations. But that's changing, and we're starting to see them, more open to investigating, issuing fines and penalties, and using their powers to make sure privacy compliance is a thing that is being followed by organizations, and that is reflected, as I'll come to a bit later, in the changes that happened in December 2022. And then finally, laws are changing. I mean, we had the December changes that I'll run through specifically to the Privacy Act, but privacy is feeding into not just the general privacy laws, but many other regulations and regulatory regimes. The consumer laws now talk about privacy. ASIC is talking about privacy in relation to company directors and cybersecurity. It's getting harder than ever to actually navigate, what do I need to do to be compliant with privacy? And so it's something, I think, if you're sort of running a business, you want to have at least a working knowledge of what the laws are and where they might come up in your day-to-day activities, because it's not just this one thing called the Privacy Act that you're sort of thinking about. It can be something that comes up in other areas of law. This slide I also like because it really shows the financial costs of not thinking about privacy. Some of these numbers are from the US, but it was showing a really big survey of organizations. $1 spent on privacy, led to $1.90 in benefits. Is sort of what this study showed, and a lot of those benefits are not legal benefits or data protection benefits or risk benefits. They're beyond compliance, better agility, increased competitive advantage, improved attractiveness to investors. So it's really worth thinking about privacy as not just a legal box ticking thing, but actually something that adds value to the business. Customers were more trusting and willing to share more accurate information and be more forgiving of data breaches. So I think, this customer experience aspect to thinking about data protection and privacy, I think, is a really strong reason why everyone wants to be thinking about it. And organizations that think about it, were 2 times as likely to avoid data breaches. And again, these things can be catastrophic for your business if they occur. So what are your legal obligations actually? Well, you might think of them in sort of 3 main buckets. The first is your general day-to-day privacy compliance. And what that means is you must collect and manage personal information in accordance with the Privacy Act and other privacy laws. So when you're collecting people's personal information, name, address, phone number, or other things that can be used to identify them, you've got to make sure you're doing it in a way that complies with the law. So that's sort of the first area. The second is about data breaches. So what happens if the information you're holding is subject to a data breach? Somebody who isn't authorized to access that information accesses it. What do you have to do? What do you have to tell customers? What do you have to tell the regulator? And how quickly do you have to tell them? So, one is day-to-day compliance. The second is if something goes wrong, what do you have to do? And the third is, what are your obligations as a director of an organization? And this is sort of a new area, but ASIC has kind of confirmed that cybersecurity is something that's falling within the duties of directors of companies and has actually forewarned personal liability for directors of companies that fail to ensure adequate security of personal information. And this is quite a substantial sort of forewarning because for those that have set up companies, which is the majority of organizations, one of the big advantages of having a company structure is that as a director or shareholder of a company, you generally are not going to have personal liability for things that go wrong in the business. But of course, there are exceptions to that. The traditional exceptions have been, if you commit fraud, improperly use your position, trade while insolvent, there are these limited exceptions where people running a company can have personal liability. And now ASIC's saying that cybersecurity and a failure to think about it and take adequate measures to protect against data breach incidents could actually result in personal liability for directors. So it becomes a high risk area actually for directors of organizations to not think about this data protection stuff. So those are probably the top three areas, and we'll kind of go through them in a bit of detail. Starting first with the general privacy compliance. So the main piece of privacy regulation or legislation in Australia is the Privacy Act 1988. And it is a federal act, covers basically all of Australia, and it talks about the protection of the handling of personal information about individuals. Now, this concept of personal information is a key concept in privacy law. And personal information is information that could be reasonably used to identify an individual. So that's, as I said earlier, a name, maybe an email address, a phone number, a physical address. It could be a collection of information that if someone put it all together, they could work out who the person is. Maybe it's a street and a street and an information about the size of a family or whatever it is. If someone could use it to narrow down who that piece of data is about, it may be considered personal information. But the litmus test is, could someone who got access to this collection of information work out that it's about a particular person? And then we're going to consider that personal information under law. And that's quite an important concept because we often get questions about, IP addresses or just having postcode data about customers or ID data about customers and using de-identified ID data to do things. If you're using ID data that, if it was disclosed or unauthorized access was granted, the person that got that data wasn't able to work out who it was about, it's probably not going to be personal information. And that's why people, often talk a lot about de-identifying data or doing their analysis or reporting on a sort of number-based level for customers rather than using people's names and emails, because it becomes a whole lot easier to deal with information that if someone got a hold of it, they couldn't work out who it's about. So when you're storing and structuring data, you might want to think about that. The law kicks in when the data has personal information, but things are a little bit more relaxed when it doesn't have that personal information. The Privacy Act talks about the collection of personal information, the use of personal information, the storage of personal information, and the disclosure of personal information. And it covers both the public sector, which have a little bit more rigorous requirements, and then the private sector, which have their own set of kind of requirements for managing personal information. So does the Privacy Act apply to you? It's worth mentioning that the Privacy Act, while it's Australia-wide in scope, doesn't actually compulsorily apply to all businesses. We have on this slide a bit of a test. First of all, are you handling personal information? And I kind of covered this already, talking about information that is about an identified or reasonably identifiable individual. One nuance to also mention is it doesn't matter whether that information is true or not, or accurate or not, as long as if it's got someone's name or something else that could be used to identify them next to it, then we're talking about, yes, it's personal information. The second is, do you fall under one of the exceptions to the Privacy Act? So probably the major exception relevant to small organizations is that the Privacy Act does not apply to businesses with an annual turnover of $3 million or less. Generally, that's not for all businesses under $3 million or less, but generally there is an exception for sort of small organizations. Now, if you're handling sensitive information or health information, or your business is all about trading in personal information, or even partially about trading in personal information, and by that we mean, you're selling personal information, or you have a referral program, or there's some way that you're monetizing people's contact information, you don't get to rely on this 3 million exception. But for many small organizations, this $3 million test means that the Privacy Act doesn't actually bind you. Now, for a lot of small businesses thinking, well, that's great, I'm under 3 mil, I don't have to worry about this. Look, that's probably not the view that we take at Sprintlaw, or many lawyers would take, for a couple of reasons. Even if you're under 3 mil, if you intend to one day be above 3 mil, it is a whole lot easier to start compliance now, because you may not even be able to use your contact lists once you get over the 3 million mark if you haven't started early. And there'll be a sort of big issue when you hit the 3.1 million mark, where suddenly your business has started breaching a whole bunch of laws that you didn't really realize when you ticked over. So it's best to be compliant from the beginning if you intend to grow beyond that mark. Even if you don't intend to grow beyond that mark, sort of what I've been trying to cover in the earlier slides is, it's not just about risk management or legal risk management. It is very much about good procedures and processes, building customer confidence, and having practices that make customers feel confident that you are handling their personal information in a way that is going to protect it from unauthorized disclosure. And being able to say that you're compliant with the Privacy Act, even if you don't technically have to be, is really great for that purpose. So it's a good yardstick for best practice. And maybe the final point on why you should think about it if you're under 3 mil is also just to mention that the privacy laws are changing a lot in Australia. There's more changes that we're expecting in the next couple of years. I wouldn't be surprised if they take away this small business exception. It doesn't exist in the GDPR, which is the UK and European privacy laws that came out a couple of years ago, which Australia has been looking at a lot and modeling a lot of its new laws off. So again, inevitably things are moving this way. So another reason just to think about doing it. So assuming you're covered by the Privacy Act, a couple of other things to consider. If you're handling what the Act calls special categories of personal information, so that might be things like tax file numbers, health information, government-related identifiers, director IDs, those sorts of things. There's some additional obligations you have. You've got to, in short, take extra special care of that kind of information and provide some additional information to customers about how you're handling it. If you're collecting credit cards, numbers, you've got to comply with PCI DSS obligations. Now, for most people, they use something like Stripe or a third-party payment service that takes care of the PCI DSS stuff. So, that aspect is generally taken care of just by your credit card vendors. But if you're not using a third-party credit card vendor, you're trying to build your own credit card collection system or collecting numbers over the phone or whatever it is, worth being aware that there are some obligations about how you store and manage people's credit card numbers. Finally, it's worth mentioning that there are some acts or practices that involve personal information that are exempt from the Privacy Act. For example, when you're collecting your employees or current and former employees' personal information, many of the requirements around, informing them about collection, use, and disclosure are a little bit lighter with employee information as opposed to external customer information. So worth being aware of that. So once you fall under the Privacy Act, you're collecting personal information about people. Well, what do you actually have to do? Well, the Australian Privacy Act takes a principles-based approach to regulation, which is some would argue a little vague and confusing for a method of regulating sort of an area. And what do we mean by principles? Well, there are 13 principles called the Australian Privacy Principles. They basically say that when organizations are handling personal information, they have to be open and transparent about it. They have to maintain anonymity and pseudo-anonymity. Sorry, that's a difficult word to pronounce. They've got to notify people when they're collecting information. They have to notify people about cross-border disclosures of personal information, maintain quality of personal information, maintain security. It sets out principles, but it doesn't actually say, you have to do A, B, and C in many cases, which makes it difficult to know if you're complying with the spirit of the principles or not complying with the spirit of the principles. And so this is where it becomes a little bit difficult to know if you're complying with the privacy laws. Fortunately, these principles have been around for quite a while, and there are established practices and procedures that if you're doing these practices and procedures, or some form of them, you're likely going to be complying with the principles and therefore likely going to be complying with the Act. And that's how most organizations approach making sure they're complying with these principles. The reason that they're done as principles and not as, you must have this manual, you must fill out this form, but more a principle approach is because the regulators recognize that over time, the ways that people use personal information will change a lot. And we've certainly seen that. This Act came out in 1988, but we have the internet now, and we have information being shared around social media and all kinds of technology systems being used. And so the principles-based approach has actually been good in being able to be flexible and survive, rapid technological change. But still, as I say, there are procedures and documents you can put together to make sure you're complying with these principles. So we have on this slide the typical suite of documents that an organization will put together for privacy compliance. And in short, if you have all of these documents and you actually use them, you're going to be pretty well there in terms of being compliant with the Privacy Act. The two most important ones are the privacy policy and the privacy collection notice, and this is for APP 1, which is open and transparent management of personal information, and APP 5, which is notification of the collection of personal information. So these two documents are pretty much mandatory, and we strongly recommend every organization consider having them. So the privacy policy is a document which sets out how you're collecting people's personal information, what you're going to do with it, who you disclose it to, how people can contact you about their personal information and what's being used for. It's a general policy informing customers as to your privacy practices. A privacy collection notice is a statement that usually links back to the privacy policy, which informs people at the time that you're collecting their information, what it's actually being used for. So, this is often quite simple. It might just be a sentence on your contact us form that says, we are collecting this information in order to give you more information about our services, and it will be handled in accordance with our privacy policy. That will be a privacy collection notice. It doesn't necessarily have to be a long document. It can be just a statement. In some circumstances, you will have a longer privacy collection notice if you're collecting people's personal information for medical testing purposes. Oftentimes you see a longer collection notice, but on websites it's often just a sentence on the contact form. But these two are very essential, and in fact are specifically mentioned in APP 1 and APP 5 as documents that are needed. These remaining documents are not specifically mentioned in the APPs, which again are more principle-based, but for best practice, these are the suites of documents that have emerged, for making sure that you're complying with them. So One is a privacy impact assessment. So APP6 is about the use or disclosure of personal information. Having some document that sort of sets out what purpose, an internal document that sets out what purpose information is being disclosed for, and doing sort of an audit of all the different areas of your business where there is personal information. So, this is something we've done at Sprintlaw. We know that we hold personal information in our email system, in our CRM system, in our core database system. We know the different areas where we have personal information. We know why it's there and what it's used for. We are limiting the areas in which personal information is to limit the impact of a potential data breach. So, and be very clear with why the information's there, who has access to it, are the right people to have access to it. So that's what we're talking about with the impact assessment. For organizations that do direct marketing, so, telemarketing or door-to-door marketing, having a policy around that. How do you use people's information for marketing purposes? People working with offshore service providers, having some agreement with them to make sure that in the way they're holding information that you give them about your customers, it's compliant with the Australian privacy laws. Data breach response plan I'll come to in a little more detail when I talk about data breaches, but having a plan for if something goes wrong, what do you do? And then finally, access request and complaint handling guidelines. So if people ask you for information, or where do you hold and what are you doing with my personal information, having some sort of guidelines for how you handle those requests. So as I said, these documents are not expressly stated in the APPs. They're optional, but for best practice, if you have this whole suite, then you're pretty well there for Australian Privacy Act compliance. There are, though, some laws outside the Australian Privacy Act which also govern privacy laws, and some of them depend on what industry you're in, what state you're in. So I've included here some common sort of acts and laws to be aware of, and it gives you a flavor for the kinds of circumstances where other laws might jump in, have some more things that you have to do to make sure you're compliant with privacy policies. For people working with health information, there's a Health Records and Information Privacy Act. In New South Wales, there's similar acts in a few of the other states, not every state. And it has specific obligations for, when you're collecting medical information or people's health records, things you need to do, to notify them and minimum security requirements for holding that information. This one applies to the vast majority of our clients is the Spam Act. If you're doing email marketing, you need to make sure that, number one, you've got consent from the individual to actually contact them. Now, that can be inferred consent, doesn't have to be express consent, although express consent is always better. Someone ticking a box and saying, I agree to receive these, marketing or promotional communications from you, but, you might have inferred consent if they're an existing client and you're informing them about your services. But yeah, the Spam Act requires that. It requires you to have unsubscribe functions on every email that you send out that is a promotional or marketing email. And many people use their privacy policy to comply with the Spam Act to get that consent. So when people fill out that contact form, it'll say, you agree to our privacy policy. And within the privacy policy, there will be a consent to receive marketing or promotional emails. And that ticks the box for the Spam Act. And this is another reason, coming back to the under 3 mil businesses, why you might want to comply with the Privacy Act anyway, because the Spam Act doesn't have a under 3 mil exception. It applies to everybody. So if for nothing else, you want to have the policy for the purposes of the Spam Act. A few other areas are direct marketing via telephone. If you're doing telemarketing, you've got to comply with the DNCRA Act. Do not call register. Make sure you're not calling people that are on the register. If you're surveilling employees with CCTV or other methodologies, there's information handling requirements. You also need consent if you're recording telephone conversations, sort of similar. So you can see there's other areas of personal information where in specific cases, there's additional requirements beyond the Privacy Act. So just because you have this suite of documents doesn't mean you're 100% okay for privacy. And what you want to be doing is, if you're doing some practice that involves handling personal information, not being afraid to reach out to Sprintlaw or some type of lawyer and getting some advice as to whether there's some policy or procedure you need to follow. I noticed we got a couple of questions in the chat. If you are compliant with the GDPR, will this mean that the APPs are covered? Good question. Look, in general terms, the GDPR, which is, for those that don't know, the UK and EU equivalent of the Australian Privacy Act, it is, in general terms, a more aggressive suite of regulations. It requires organizations to do a lot more around the handling of personal information. So in general terms, if you're completely compliant with the GDPR, you're going to have ticked the vast majority of the requirements of the Australian privacy laws. But it won't be 100% because there are differences between the two. So for example, in the service agreements, you specifically would need to include a clause if you're dealing with overseas recipients that says, the overseas recipient agrees to handle personal information in accordance with Australian privacy laws. If you're not mentioning Australian privacy laws there, then you may not be compliant with this procedure and process. Also, the data breach regime and the response plan in Australia and the steps you need to follow, which I'm about to come to on a forthcoming slide, is a little bit different to the UK Act. As Australian regulators, you have to notify. So it's maybe 90% are going to be covered, but there'll be a few sort of areas where there's Australian specific stuff that you might need to adjust your GDPR documents for compliance with the Australian laws. Hopefully that gives a sense of the answer to that one. So let's talk about data breaches. I think this is the area that a lot of people are interested in right now off the back of the Optus and Medibank incidents. What happens if you are subject to a data breach? What happens if a ransomware attack occurs on your organization? Somebody who isn't meant to access your customer's personal information gets access to it. What do you need to do if it happens to you? The Privacy Act sets out the notifiable data breach scheme, which covers the steps that you need to follow if a data breach occurs. So I'll run through these steps in a little bit of detail. One very important point to mention is that the same requirements we ran through on this slide, does the Privacy Act apply to you, applies to the notifiable data breach scheme. So generally, if you're under 3 mil, you don't have to comply with the notifiable data breach scheme. It's still a really good sort of list of requirements that you should consider sort of complying with, because it's kind of best practice. But the actual scheme may not apply to you if you're a very small organization. So keep that in mind as I'm going through this stuff. So if a data breach occurs, well, first of all, you want to work to contain the data breach. So we've got here, data breach is unauthorized access to or unauthorized disclosure of personal information or the loss of personal information that the business holds, which includes effective control over the information, such as where a business engages a service provider to hold personal information on their behalf. So it's not just a data breach of you, it could be a data breach of a supplier of yours that holds your customer's personal information. That is a data breach. So the first step you want to take before you do anything is work out how to contain the breach. If there's a way to limit the access of the intruder to the information, delete some information from wherever it is where it may not have yet been accessed. Any action you can take to contain the breach is going to, number one, reduce your legal risk, and number two, make the process a lot simpler from steps sort of 2 to 4. So, we always say as soon as this happens, and it's kind of common sense, but take as much remedial action as you can. If you can actually limit it to a degree where there's very minimal harm to affected individuals, you may actually not need to follow steps 2, 3, and 4. Because as we come to step 2, the next thing you have to do is assess whether the data breach is likely to result in serious harm to affected individuals. So you only have to follow these notification steps if there is serious harm. If there is not serious harm, you kind of can keep it contained, and there's not much more you need to do. So obviously the big question is, well, what is serious harm? And as is the case with the way the privacy regulators like to draft the laws, they haven't defined really what serious harm is. Only to say that serious harm is where where the business holds a reasonable belief that serious harm has occurred. So it probably will take, as interpreted, a common sense meaning of what serious harm is. If you have, for example, accidentally forwarded the name of one of your customers to a third-party supplier of yours that shouldn't have had access to that information, but there's not really anything they can do with it, and they're not likely to do anything with it, it's probably not likely to result in serious harm. If you're on the other end of the spectrum, subject to a ransomware attack where people are threatening to release all of your customer list on the dark web, including their name, phone number, and passport, that's definitely serious harm. And so it's a spectrum from the innocuous accidental email forward all the way through to a full-blown cyber attack. And you want to be thinking about, okay, well, this information that has been disclosed by accident or by hack or whatever it is, if someone were to get a hold of it, what could they do with it, and what harm could it cause the individuals? And that is sort of what we're talking about in this assessment. Lawyers can definitely help at this stage in terms of assessing whether serious harm has occurred or not. Lawyers will never give you a yes or no answer. We'll just give you a high, medium, low risk answer, because unfortunately the term is not defined in the Act. And of course, if in doubt, it's always safer to assume that serious harm may have occurred and proceed to the notification steps. But certainly we've had many cases with clients where it was very much an innocuous, unauthorized disclosure, and we considered it low risk that serious harm had kind of occurred. So step 3, if serious harm has occurred, then you have an obligation, if you're covered by the Privacy Act, to actually notify the regulator, the Privacy Commissioner, as well as the affected individuals. And so what you have to do in these circumstances is, first of all, fill out a form on the OAIC website saying, we've been subject to a data breach, here's what happened, or contact them using some other contact details. And secondly, somehow contact the people who have been affected. So you may send them all an email. Some of you may have received emails like this before. You have been subject to a data breach. This is what information of yours was disclosed. Here's kind of what we're doing. Please let us know if you have any questions. That's the kind of notification that we're talking about. Now, if you can divide up the list of affected people by, some didn't suffer the risk of serious harm and others are at big risk of serious harm because maybe they got more information about some over others, you can choose to notify just the subset of people that were at serious risk, so you don't have to tell sort of every person, and that may be a decision you choose to make, if you want to limit the risk to your reputation. Thirdly, if you can't do option 1 or 2, maybe you can't work out who was affected, or you just don't have up-to-date contact details for them. You can publish a statement on your website. There's a word missing there, but publish a statement on your website, or some other public statement, doing your best to let people know that their information may have been affected, and providing them with your contact details to contact you. That's kind of what's involved in a notification. After you've done the notification, there's an obligation to conduct a root cause analysis. What caused this problem, and what can we do to prevent similar incidents occurring in future? And this may involve engaging, cybersecurity experts, or fixing up your systems and changing the way you hold information to protect against unauthorized disclosure. So that's the kind of 4-step process. Now, what are the costs of a data breach? Well, if you don't comply with these 4 steps, you could be just fined by the privacy regulator, and you could be required to pay compensation to the affected individuals. Now, if the breach is the result of your negligence, or you haven't taken reasonable steps to prevent against the data breach, you may still be liable anyway, even if you comply with these steps to affected individuals. But if you can show that you comply with these steps, it's going to reduce your liability. And furthermore, if you have these documents in place, it's going to further reduce your liability, because what you'll be showing if there is some claim against you is, look, we did our best. We had policies and procedures in place. We notified as soon as we could. We shouldn't be liable for this. It kind of wasn't our fault. It was the criminal act of a third party. And that is a sort of very valid argument for reducing your liability. So that's why some of these things matter. Those are the sort of legal costs of a data breach. Of course, there's non-legal costs. We've talked already about the importance of privacy protection, data protection for reputation. So reputational damage, customers may lose trust, suppliers may lose confidence, and ultimately your revenue is going to suffer if these things occur. It's not a fun thing to receive from your service provider, a message saying, hey, you trusted us with your personal information, and we lost it all, or we've put you at risk. You probably don't want to work with that organization anymore, or that could happen. So there is reputational damage. Again, the way that you run this data breach process, the way that you send that notification really can make a big difference. And we have this stat from my earlier slide, which said that customers were more trusting and willing to share more accurate information and be more forgiving of data breaches to organizations that actually care about privacy. So even if it happens, if you deal with it well, you can limit this reputational damage. And then finally, of course, there's IT costs in dealing with the breach. So now we'll just move on to another area, access requests and complaints. So this is more in the day-to-day handling of personal information. What information can individuals request to know in terms of what you're holding about them? Well, under the APP number 12, individuals have the right to request personal information held by a business. So someone can ask you, please tell me what you're holding about me and what you're doing with it. There's no formal requirements for making the request. They can just email you or contact you, and they have that right. Now, can you refuse it? Generally, no, you can't refuse it because you have an obligation to comply with that request, except that there are sort of 10 grounds. These may include where it's very expensive or impracticable to get the information. It's not disclosable for regulatory purposes or government purposes. And there's a few other sort of limited grounds under which you could say, well, look, we actually can't provide you with access to this personal information. But if you are refusing it, you do have to at least respond and give reasons for the refusal, and explain to them that if they disagree with your refusal, they have the option to make a complaint to the privacy regulator. Best practice for handling these complaints is to have, ideally a dedicated person like a privacy officer. Doesn't have to be their full-time job, but in the same way organizations sometimes have a fire warden, you might have a privacy officer. Or if that's not practicable, at least an email contact which can handle these requests. And usually that's included in the privacy policy. So at the bottom of a privacy policy, it'll say, if you have any access requests or want to complain about our practices, please contact us here. Assuming you have that, you'll be pretty well on the way to compliance with the Privacy Act. What will then happen if someone wants to complain about your personal information handling practices? They can't go straight to the regulator. They first have to at least contact you, give you a reasonable time to respond, it can be referred to a third-party dispute resolution scheme before they're able to actually complain to the regulator. And again, the regulator is going to work, to resolve the complaint rather than necessarily fining you. But if you don't have proper procedures and processes in place, this can be a real way where the regulator finds out, that you're not complying with the Privacy Act because, one person complains to them, and that can be where some of the issues actually emerge in practice. So we've covered a lot of the compliance stuff and the law stuff. Of course, data protection and privacy protection is not just about having policies and procedures and documents. There's other non-legal things that you might want to think about. Some of these, are not things that Sprintlaw help with because we're a legal provider, but we can at least point you in the direction of other procedures and processes you might want to think about putting in place in your organization to protect against the risk of data breaches and privacy breaches. So the first is having some form of cyber insurance. We pretty much recommend that any organization that holds personal information digitally of their customers considers cyber insurance. There are potential significant costs, even if you are complying with all the laws in rectifying even just the technical costs of rectifying a ransomware attack or a data breach. So having some insurance policy that covers you for that is increasingly becoming something that is being seen as normal by businesses. And we recommend a lot of our customers consider taking one out. We certainly have one at Sprintlaw. Second is considering cybersecurity reviews of your systems. So having IT experts actually review the way that you're handling people's personal information and the systems that you use to handle it, and making sure that you take their recommendations on, introduce processes and procedures to ensure that you're as robust and protected from these data breaches as you can be. Conducting these reviews is good for liability purposes. If you can show you conduct them, let's say once a year or once every 6 months or whatever frequency, you can show you're taking reasonable steps to protect people's personal information from unauthorized disclosure. But it also will help prevent the risk of things going wrong. I've got on here, MFA and backups. We've done these reviews sort of regularly with our IT cybersecurity vendors. And the two things that they strongly recommend all organizations do is, where possible, turn on multi-factor authentication. So, for people that don't know what that is, it's when you have a username and password, but you try and log in, and it requires either an SMS or some other application, 6-digit PIN to authenticate. The risk of unauthorized logins, from what I understand, goes considerably down in organizations that have multi-factor authentication turned on, and it's quite easy to do. So if nothing else, if you can't afford the reviews yet, at least look at turning that on, and having backups, to reduce the potential business risk of ransomware attacks. That may not stop the risk of unauthorized disclosure of personal information. If someone takes all your data and customer data, just because you have it backed up doesn't mean that you're protected against the fact that a breach has occurred, but it can at least reduce the business risk. A few other things here: security training, having cybersecurity policies and processes, training staff on how to recognize phishing attacks and other sorts of IT scam practices. And then these PII registers and reviews, I touched on these earlier with the impact assessment. I think it is just very good. A lot of organizations don't do this, to go back and look at your systems and work out, where is personal information actually held? I mean, we know it's in emails because that has people's name and email address. So, who's your email vendor? Is it Gmail, Outlook, or someone else? And how's that protected? Where else is it? Is it in spreadsheets? Is it in Google Drive? Is it on random people's desktops, that are downloading documents with your client's contact information? How can you stop all the different places where your personal information is from, being so spread out? Can you limit it and, limit the scope of potential areas for failure or data breach? And that's one effective cybersecurity mechanism that organizations do. And then they keep a register saying, okay, well, we have 8 systems that handle personal information. Here's how we protect those 8 systems, and here's what information each system has, and keep that updated. That's a really good, simple way of getting on top of where the personal information is. So got about 10 minutes left. I'm just going to quickly go through, maybe for the next 5 minutes, the changes in the laws that happened in December. And then I'll try and get to any questions in the Q&A. If you have any, now's the time to drop them in so I can sort of have a look at them after I run through this section. So what's actually changing under the law? So in sort of mid-December 2022, in response really to the Medibank and Optus data breaches, the government changed the Privacy Act under the Privacy Legislation Amendment, Enforcement and Other Measures Act, and it was kind of fast-tracked, after those breaches. It had been discussed for a while, but it went through quite quickly and was passed on 12th December. And what it does is amends the Privacy Act 1988 with a series of fairly significant reforms. And it's the biggest change in about 4 years to the Act, which, the last one was the introduction of this data breach scheme. So there's kind of 3 areas of changes I want to run through. I mean, the first is it expands the extraterritorial reach of the Privacy Act. What that means is for non-Australian organizations that are handling Australian information, there's more of a requirement for them to comply with the Privacy Act. Previously, they needed a fairly strong Australian link. That link has been loosened. So the net effect of this is, more international businesses operating in Australia or collecting Australians' personal information will need to comply with the Privacy Act. The second big change is increased penalties for interferences with privacy. There's now really big fines that are potentially issuable by the OAIC for people that fail to comply with the Privacy Act. For individuals, it's 2.5 million. For organizations, it's up to 50 million, and it could potentially be even higher for higher turnover organizations. So these are the maximums. So may not be that big. It'll always be in relation to the severity of the breach, but it means really, really big fines could be issued. And as I mentioned, we're seeing a rise in enforcement action. So the idea that, I've never been pinged before for issues with privacy compliance in the past is, I think, not necessarily reflective of the future. And I think we're going to see, penalties being issued for smaller and larger organizations alike as the regulator starts to have a bit more power and, to enforce the privacy laws. And sort of on that, the third area of change is in fact increasing those regulator powers. So the Privacy Commissioner now has more information to request information and documents about suspected data breaches and conduct assessments of an entity's compliance with the scheme. So if they receive complaints about organizations' data handling or privacy practices, they can contact the organization, ask for lots of information, and they have the regulatory right to get that from you. ACMA, the spam regulator, and the Privacy Commissioner, for example, are now able to engage in interagency information sharing. So if there are spam complaints made about you to ACMA, they could refer that over to the Privacy Commissioner, who may then launch an investigation of your organization, or vice versa. If the Privacy Commissioner finds an issue, they can refer it to ACMA for looking into spam issues. So another way where the scope of the regulators to kind of look into your practices is increasing. And finally, they've got more enhanced enforcement powers. So it's not just about issuing fines. They can require you to publish statements on your website, to engage independent advisors at your cost to fix issues, and other remediation measures. And there can be penalties if you fail to comply with those enforcement powers. So the regulators are getting stronger. The fines are going up. And that kind of goes back to what I said earlier about it being very important to think about privacy protection, as the environment changes. I'll just address a couple of the questions that have been raised in the Q&A. First one, what's the current requirement when using systems overseas and where private information is stored as part of that? In the past, I was of the view permission of the persons whose PII is involved needed to agree to that. Yeah, so look, I think a lot of organizations now will be using softwares or suppliers that are not based in Australia. If you're using a CRM system or even an email system, it may be that the data in which your customer's personal information is stored is not located or hosted in Australia. And the general position, and I kind of covered a little bit of that in one of the earlier slides about having these service agreements. Typically, there's 2 things you need to do. One is inform the customer of that fact, as you alluded to, which you typically do in your privacy policy. There's a paragraph that says, your personal information may be shared with overseas suppliers. We will do our best to ensure that they are complying with the Australian privacy laws in the way that they handle your personal information. So that'll be the permission aspect, where you're getting their permission to share it overseas. And secondly, then you're going to want to have a contract of some sort with that overseas entity. And that's either a service agreement with the clause that says hey, we are giving you our customers' personal information. You agree to comply with the Australian privacy laws. Or typically, if you're using, some sort of software vendor, they will have their own terms and conditions that you agree to, and you just want to check in those terms and conditions that they agree to comply with your privacy laws. Most organizations that operate in Australia, if they're a SaaS company and their T's and C's, they will have something about privacy, but it's on you to make sure that they have that clause. And then from the customer's perspective, you've promised them that you're going to handle their personal information in a certain way. You've told them you're going to share it overseas, and then you have a contract with the overseas people, getting them to legally agree that they're going to comply with the Australian privacy laws. And that's kind of the way that you manage the overseas sharing of personal information. Another question, what should boards be doing to reduce their risk? Look, I think it's a lot of the stuff I covered in the presentation, I think is the best practices. So the more of the stuff I've been talking about that you're doing is going to be really good from a risk management perspective. Like if you have the full suite of these privacy documents I have on screen now, that's a really good step one. You're going to be showing that we're taking privacy compliance seriously, and we are doing the maximum we can to put documents, procedures, and processes in place to comply with the privacy laws. So that's one area. The second area I raised early on in the presentation, though, was that potential director personal liability for cybersecurity and failure to take adequate measures to protect against cybersecurity. So in addition to the privacy stuff, I think you're going to want to have these data breach plans in place, procedures and processes if a data breach occurs, but also be taking these other prudent steps. Getting cyber insurance, ensuring that regular cyber reviews are undertaken, putting together security training policies and processes for your organization, reviewing where the personal information is held. What you want to be doing is have some documented evidence. We are regularly thinking about cybersecurity. We're regularly protecting against risk in relation to cybersecurity. We have all these policies and procedures. It'll be difficult in those circumstances for ASIC or a regulator to be saying you're not taking reasonable steps, even if a cyber attack occurs, because you can show this history of regularly engaging with it sort of to the best of your ability. So there's no sort of magic bullet answer to that question, but I think the more of this stuff you're doing, documenting and on a regular basis, the lower the risk is going to be of any kind of liability. So I think that covers most of the questions. Just a reminder for those that are interested, if you don't have even the basic docs in place, you can get this discounted bundle, 500 plus GST we're doing for all of Feb. And if there's other documents I mentioned that you want to get, it's a 10% general discount on all privacy related legal services. If you're a Sprintlaw member, an extra 10% on both of those things also available. And that's about it from me. Hope everyone found this presentation useful and enlightening. If you have any questions, definitely feel free to reach out to our team. We're looking at doing webinars like this fairly regularly on a variety of different topics. So if people have feedback or ideas or things I'd like to hear about, we're very keen to hear about it. And hopefully we'll see you at one of the next ones that we do. Thank you all so much for your time.